How do you prove divorce grounds without clear evidence? Imagine trying to show someone did something wrong when you have no proof at all. That's often what happens in family law when someone wants to prove grounds for divorce but lacks clear evidence. It can be tricky, but there are ways to handle this situation. First, it's important to understand the burden of proof. The spouse claiming fault-based grounds has to convince the court that misconduct like adultery, cruelty, or abandonment actually happened. Usually, this means providing credible evidence, witness statements, or documents. Without solid proof, meeting this burden is tough. If direct evidence like photos or written admissions isn't available, courts can consider indirect or circumstantial evidence. This might include patterns of suspicious behavior, financial records showing misuse of money, or witness statements about odd conduct. For example, if one spouse suddenly moves out and stops communicating, that could suggest desertion. Courts look at whether this kind of evidence reasonably supports the claim. Many places now allow no-fault divorces, which don't require proving any misconduct. Instead, you can cite reasons like irretrievable breakdown of the marriage or irreconcilable differences. Sometimes spouses have been separated for a certain period, like 6 months or a year, which is enough for a no-fault divorce. This approach often makes the process quicker and less stressful because you don't need to gather proof of wrongdoing. Even if you suspect misconduct like adultery but lack proof, it might still influence other parts of the divorce. For example, if one spouse wasted marital assets on an affair, the court could consider that when dividing property or awarding support. However, unless the misconduct directly harms the child's well-being, it usually doesn't affect custody decisions. The accused spouse can also challenge fault claims by raising defenses. They might say the misconduct was forgiven or that both spouses are at fault, which is called recrimination. They could also argue that the allegations are false or exaggerated. Without strong evidence, these defenses are easier to assert and can prevent a fault-based divorce from being granted. If you're in this situation, it's smart to talk to a family law attorney. They can help you evaluate what evidence you have and decide whether to pursue fault grounds or opt for a no-fault divorce. Gathering any documents, communication records, or witness statements can be helpful. Sometimes, mediation or collaborative divorce methods are better options, focusing on settlement rather than proving fault. Keep in mind that courts generally require credible proof to grant a divorce based on fault. If proof is lacking, no-fault options are often the best route.